I'm National ERISA Disability Attorney Nancy Cavey. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to tell you that, and I've done that. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, we're going to be talking about brain disorders and disorders impacting brain health. I've done some episodes before, but I wanted to give you an update. I want to talk about a few more conditions that can have a severe impact on the brain and consequently cognitive and physical abilities, and then how that translates into an ERISA disability claim. Brain, cognitive, mental health, all of this is vital to our well-being, not only in our personal life, but in our work life. I find that disability carriers often don't make it easy for people who have issues with brain functioning to get the disability benefits they deserve. Why is that? Well, often they'll try to apply something called the mental nervous policy limitation for brain conditions. And I'm going to be talking today about a number of brain-based health conditions, how disability carriers handle these claims, and how to get the disability benefits you deserve. So first, let's talk about the impact of gaps in treatment in your traumatic brain injury in an ERISA disability claim. Next, I'm going to talk about bradykinesia and your ERISA long-term disability claim. I'm going to talk about Parkinson's disease secondary to solvent exposure and your disability claim. And I'm also going to talk about cognitive problems and your thyroid ERISA disability insurance claim. Let's take a break before we get started with this episode. Welcome back. We're going to talk about the impact of gaps in treatment in your traumatic brain injury ERISA disability claim. Now, I'm sure you know that accidents are the leading cause of traumatic brain injury, and they give rise to not only ERISA disability claims, but Social Security disability claims. I will tell you, as an experienced brain injury, ERISA disability, and Social Security lawyer, that one of the things that I find problematic are gaps in medical treatment. So I'm going to illustrate this problem and how disability carriers and courts can react to this gap in treatment. So this is the story of Claude Aucion, a project manager who worked for Greenberry Industrial. In 2019, he hit his head on a piece of metal while vacuuming his truck at a car wash, but he continued to work until 2021. He claimed he had traumatic brain injury, headaches with migraines, mild neurocognitive disorders, tinnitus, imbalance, emotional instability, and insomnia. His employer approved his short-term disability claim, but then denied his claim for long-term disability on the basis that he did not meet the policy definition of disability. Now, before you stop work and apply for benefits, please get out that disability insurance policy or plan and read it cover to cover, because there are definitions in these policies that can limit the payment of benefits. The carrier in this case took the position that the medical records did not support any significant head injury, that the onset of his impairment was really inconsistent with what was in the medical records, and that the claim of disability was based on self-reported symptoms alone. They said, hey, look, there's no loss of evidence of consciousness, no interior grade amnesia, no retrograde amnesia, no medical attention at the time of the accident. There's no clear findings on the MRI. There's no clear findings on pathology on an electroencephalogram. And by the way, you continue to work post-injury. And we think there are signs of somatic symptoms disorder. That's a lot of bases or reasons for a denial, isn't it? But this type of denial and this kind of language is not uncommon. You can imagine that this case ends up in federal court. But what was interesting in this case was where the court went off as opposed to where the disability carrier went off. Even though one of the claimed reasons for the denial was not the frequency of treatment, The judge went off on that particular issue. Now, I will tell you, many disability plans do require that you get appropriate, reasonable medical treatment. And in this particular case, that's was the basis of the judge ultimately upholding the denial of this claim. The judge obviously is going to look at the medical records. And if you're not getting medical treatment, there has to be an explanation as to why you're not getting treatment. Now, in handling traumatic brain injury cases, I do see this quite frequently because the individual will deny that they have any cognitive issues as a result of the TBI. They are in denial when, unfortunately, and often, people around them know they're having cognitive issues. So there is this refusal to get treatment, which I think is in part based on the nature of the injury. But in any event, in this case, the judge noted there was a gap in the treatment history, and the treating physician was opining that Ancion could not do his occupation as a project manager, despite the fact that during the time that allegedly he couldn't do this occupation, he was in fact doing his occupation. So this gap in treatment while he was doing this occupation, combined with an opinion of the doctor that said he couldn't do his occupation, just was a whole muddle that the judge could not get through. So ultimately, the judge questions what's the validity of the doctor's opinion that he couldn't work. And they couldn't explain that. And as a result, the judge upheld the denial. But in my mind, this case illustrates three issues with TBI claims. And the first is, why is there a gap in the treatment when the claimant is working? Is it because he's not having any problems? Is it because he's refusing the treatment? And by the way, exactly what was he doing? Was he functioning at the level that he did function prior to hitting his head? What do the employer's records talk about his performance? What were his performance reviews? Also, this leads to the second issue, and that is, okay, well, what changed in his medical condition that led him to stop work and apply for disability benefits? Was he beginning to have symptoms that impacted his cognitive functioning, his ability to sequence, his ability to stay on task? Was he missing time from work because of the migraine headaches? That obviously needs to be explained, and it needs to particularly be explained if there are documents or records from the employer that show he's beginning to have problems functioning in the workplace. He might have been reprimanded. He might have been missing time from work. He might have had difficulty completing tasks on time or getting along with others. The records need to speak to this. And then the other issue is, does this lack of treatment contribute to the subsequent disability? Now, as I've said, it's not uncommon for people who have TBI to deny they have a TBI and to minimize any problems that they're having, and as a result, not get treatment. But when the person ultimately gets treatment, I think in any ERISA disability or even a Social Security claim, you've got to address, what was the injury? What was the nature of the injury? Were they able to work? If they were able to work, what were they able to do or not do? Were they having problems performing work? What changed to allow them to seek medical treatment or to have difficulty working? And what impact did this lack of treatment have on the subsequent disability? I think that these issues should be anticipated and addressed in every TBI claim. And as a result, in this case, since they weren't, the judge upheld the denial of his long-term disability claim. I think that proof in a TBI claim is crucial, and simply claiming you have a TBI that you can't work is not going to cut it. It really requires the skill of an experienced ERISA TBI attorney who can look at the medical records, look at the policy, take those records apart, and anticipate, as I've indicated, just some of the many defenses that you're going to see a disability carrier raise to a claim. Got it? Let's take a break.